Thank you. Let me first say, Judge Kwong, I appreciated your remarks on Levine, and I'm trying to find a common theme because I thought they were absolutely correct. That is to say that Levine at the Supreme Court proceeded in Wonderland and looked at the decision below in a way that was not consistent with the reality of causation, because in the doctor's testimony, the only thing that would have prevented the treatment that Ms. Levine received by the doctor was a warning.
As a sitting judge, I express no opinions on pending cases.
Well, it's not pending, it's over. But I think that it's fair to say that as the plaintiff's lawyer argued, what the plaintiff sought was an instruction that said under no circumstances may you push this in. That, if the case had been framed as a conflict between that causation factor and the decision of the FDA taking into account the risk, the very risk that occurred in the case, which led to a decision that the option should not be removed from the physician, would have been a much harder case. And the Supreme Court made it much easier, in Justice Stevens' opinion, by saying, well, we don't know why the labeling was defective. Maybe the warning could have been written in other words. We don't know why the jury decided what it did. That made a very different case of it, albeit one detached from reality. But that's an editorial remark. And I think then when we get to Conti, we're the same thing. You can recite legal formulas, but when you come back to reality, what's this case say? This case says that the seller or the manufacturer of a product, the branded product, who advises through the PDR physicians of information relating to its product for the purpose of ensuring that its product will not be deemed unreasonably dangerous. To wit, it is complying with 402 Section K by saying, look, there may be a risk in this product, but let me warn you about the risk. When you do that, when you undertake to make your product reasonably safe, you somehow now have become the indemnitor of generic companies which are going to sell the same thing, and they're going to get the profits and the benefits, and you're going to get the liabilities. That's the result. That's the reason why every other court that's looked at this, including 2 courts after the decision in Conti, have said that's nonsense. It's bad policy, it's unfair, and it imposes a duty where none should exist. Now, the core problem, I think what drives Conti is you've got a lady who's been hurt. She has tardive dyskinesia. It is not a trivial disease, and it's lifelong. And this is, and this drives courts to say, well, what are we going to do to compensate? Because after all, everybody should get compensation through the tort system, whether or not they've actually targeted someone who's to blame. So to compensate, the court starts to look around and says, well, we got a problem here. The problem is that the person who benefited from the sale, the generic manufacturers who actually made the product, have cleverly not told anybody anything about it. They have complied with federal law because they bundled into the wholesale shipment the product label that they use. They copied that from, as they're required by law, from Wyeth's label, but nobody ever sees it. So they've been invited to essentially distribute an unreasonably dangerous product, but because of causality, no one relies upon it. California law allegedly doesn't make them liable. So we've got a problem here. How are we going to solve the problem? And Valerie comes up with a very clever theory and says, let's just say this is a fraud committed by Wyeth because they put a label out that other people could read, and in doing so, they just assumed a duty to the world, to all physicians who want to prescribe this drug. And that's what the court says. As she said, they started from the concept that foreseeability means duty. If you can foresee that somebody's going to rely upon what you say to take an action, you now have a duty to be absolutely accurate for fear that they will misunderstand or come to a wrong conclusion and act erroneously. Whether or not you intended to reach out to that person and whether or not there's privity, because no privity here in the conventional sense between Wyeth and the customer who bought something else. I mean, there's no privity, one, because they don't have a direct relationship, and two, they didn't even buy your product. But somehow we're going to say foreseeability is duty, which would also say that a doctor who produces a case note saying I've had a favorable experience with drug X and realizes perfectly foreseeable somebody else might rely upon that, now has a duty to the whole world that's read the case note and decided, that's something I ought to try. And maybe he was wrong, and maybe he wasn't careful enough in preparing that case note and didn't take into account adverse consequences and disclose them. Well, we ought to sue him too, because under Conti, you can do it so long as the so-called Rowland factors, which is what Valerie talked about, are balanced in favor of the duty. And what are those factors? They're pretty circular. The first one is foreseeability. It's the same factor that led you into it in the first place. The second one is certainty of injury, meaning, well, it's kind of like foreseeability, because if you misrepresented the product and failed to disclose its problems, well, it's pretty certain there'll be injury. Moral blame simply is the same factor. You didn't disclose it accurately, therefore you're blameworthy. And then we have deterrence. Now, how deterrent is it? One thing is, sure, if you say that the consequences of a label that's inadequate are that you guarantee and indemnify everybody who ever sells the drug, you'll have more deterrence. It's obvious, more pay, more deterrence. But is there no limit to this? And what kind of deterrence is being imposed on the people who are selling the drug? Selling, in some cases, 95% of the drug. They're not deterred at all because they've got someone to indemnify them, and their best strategy is don't tell anybody anything. Is that a sensible policy? Does that lead to deterrence? And I think that's something probably Valerie and I agree to, that the result, as it read on generic manufacturers, was a horrifying result from a public policy point of view. Because it said, don't make your product safe, but as long as no one can rely on the absence of information, you're golden. That had to be wrong. And then there are various public policy factors which are discussed. There were two cases that the court relied on in Conti. Both were cases where the person who was alleged to have the duty volunteered information in a context in which there was a direct relationship. One was a parole officer who told the potential target of his parolee, don't worry, he's okay, won't do it again, and he did. But there was a direct privity and there was an assumption of a duty. The second was a school district that advised another school district that a certain kind of a teacher who had a certain behavior pattern was really quite safe, and he wasn't. But again, there was an assumption there that I'm going to advise you, and it's in my interest to do so. I don't have to do it. Here, Wyeth, in order to sell its drug, takes up the responsibility of providing information in the PDR, publishes it, doesn't have to publish in the PDR, and in fact with some drugs, because not necessarily this decision, but risk, if you look for phenogrin in the PDR, you won't find it, because the branded seller, who turned out, Wyeth sold it to Abbott, but the branded seller says, I'm not going to get caught again. I'll just, as soon as that drug goes generic, I'll take it out of the PDR. So no one can rely on me. And the generic seller says, I'm not dumb enough to put it in there. No one can rely on me either, and we'll have a perfect solution, no relief. That's what this case is leading to. That's why, two courts subsequent to Conti have repudiated it, both in Oklahoma and Nevada. They're federal courts, and why it makes no sense at all. It's one of those cases where the manipulation of legal concepts detaches us from the reality of the case. And if the court had exercised as much imagination in finding a legal theory to hold the actual sellers responsible and to say that the way you protect yourself as the actual seller is to get your labeling right and to get that advice in the hands of the doctors who need it, you would have had a far superior result. Because under federal law, while a generic must copy the label at the date of approval, the FDA has made it perfectly clear that a generic, if they believe that that label is insufficient, can come in and amend their own label and actually force an amendment of the branded label. So, think about reality. You've got a lot of drugs out there in the 11,000. Many of them have gone almost fully generic. Branded sales go almost to nothing. Branded manufacturers can quite handily remove their information from the PDR because they've either stopped selling or it's so de minimis they can't sell. And nobody will be advised. And that's where Conti is taking us, and that's why I think the courts that have said no to it are right, and that's why I think that it would be sensible public policy to focus on the real issue, how to hold the actual seller responsible for the product that that seller makes available to the public. One other note on Conti to show you how kind of bizarre it was. There was another issue up on summary judgment, and that was what did the doctor rely on? Had he actually relied on any label at all? And in that regard, the testimony was, which is repeated in the opinion, was that the doctor said, well, maybe when I was in medical school, which was 15 years before the event, I might have read the Rowland label, which is the branded label, in the PDR. And in general, you know, I think the PDR is pretty good. That was the testimony. So that raises the question, how is this tort of misrepresentation, which is invented here, to be construed? You have a communication that is either negligently or affirmatively false. That's one element. You have to have reliance thereon, and then you have to have consequence. Interesting question. What was the date of the negligent misrepresentation? Was it 15 years before the event? That's the only time you could be sure that the doctor had looked at anything, and the court said that was sufficient. So you have event one, then the reliance takes place 15 years later. Does that make any sense? Is it foreseeable that what you say in 1990 is going to be relied on in 2005? I mean, and once you start down the road with these torts, they're going to raise all kinds of other questions that really are needless because the tort shouldn't be there in the first place. And Victor, I'll turn it over to you.